Only that in relation to the judgment itself, the prosecution is very pleased that the findings of fact supported the prosecution's position that was put forward in the case, particularly in relation to the fact that Doig was a willing participant in the crimes. As you know, the defence were putting forward a mitigation circumstance or an acquittal point that he was acting under duress. The court found against that. And I think that's very important for the Cambodian people to understand that not everyone in the Khmer Rouge regime were forced to carry out those acts, but that Doig was an instigator behind them. In relation to the sentence itself, the prosecution asked for 40 years. Now that was taking into account a reduction in sentence for the illegal detention and also taking into account the reduction in sentence for his limited cooperation. So the difference between the prosecution and the trial chamber, what we requested is in fact 10 years, and as Andrew has said, we're reviewing the judgment at the moment to determine whether that should be appealed or not.
Some civil parties have mentioned that they had hoped that the prosecution would ask for a longer sentence. Can you comment on why you chose 40 years rather than a sentence either of life imprisonment or something in between that would seem to be a little bit more severe?
I mean, as you know, in our submissions to the court, in our written submission, in the oral submissions, we started off with life imprisonment because we felt that the seriousness of the crimes, the numbers of deaths, the way in which Doig was involved with them warranted a life imprisonment. However, as you know, Doig was held in custody for a 6-year period, which was illegal prior to the ECC commencing. And the international law tells us that there must be an express and measurable discount which must be taken into account in sentencing if that situation occurs. And so that's why we asked the court for 45 years, and on top of that, recognition that there was some limited cooperation. So that's why we ended up with 40 years, and on that basis, of course, that would be another 30 years in custody from the time that the judgment was passed down, which in effect would be a term of the life imprisonment.
There has been some discussion under Cambodian law. After a defendant serves 2/3 of his sentence, he is eligible for release, early release. Can you comment on whether that provision of Cambodian law would apply to Doig and to other defendants at the ECCC?
Well, the view of the co-prosecutors is that the parole provisions under national law only apply to national crimes, but don't apply to crimes being prosecuted under the ECC statute. The reason for that is the ECC statute has looked at the other statutes, the other tribunals, and they have expressly left out the provision of a commutation of sentence, which would in fact be parole. And as the national parole provisions relate to less serious offences than crimes against humanity, it's certainly the prosecution provision that the statute, the rules, expressly exclude parole provisions. And that's consistent with international standards that the court that issues the sentence, even if there is a parole provision included in that statute, has the ultimate say when the accused is released from prison. And the same situation occurs at the ECCC, where those parole provisions have not been included expressly for that reason.
And that's actually the view of our national colleagues too, so we're in unison with that.
That's good. Can you comment on the importance of this judgment as it relates to case 2, especially in light of the fact that the court recognized that there was an armed conflict at the time, they accepted the theory of joint criminal enterprise. How will that affect the prosecution's strategy in case 2, and is that a positive aspect of this judgment moving forward?
I mean, I think that's extremely positive. All of the things that you mentioned, the fact that international armed conflict has already been found by one trial chamber, obviously we can use that as an element of proof in the next case. The fact that joint criminal enterprise, which has been a hard-fought battle in this court, has been recognised and applied by the trial chamber in its first 2 forms, is an extremely beneficial position for the prosecution to find itself in. I also think, a further matter that you didn't mention is the hierarchical structure that the trial chamber found within the Khmer Rouge. Also, extremely useful findings for us as the prosecution going into the next case. We're dealing with the most senior remaining leaders of the Khmer Rouge. So from that point of view, all of those factual findings are very, very positive for us going into the second case. Bill?
I also think the way in which the findings were found, they were found on well-argued fact. They applied international law, and I think that's a very good augurs well for the approach that the trial chamber will take to bringing international law into this court. And also I think provides a good example, or perhaps model, in how judgments could be rendered in local courts by having good reasoning, relying on law that's expressly stated. And I think that the judgment should have some beneficial effect for local courts and perhaps in how to distribute and make their findings.
And indeed, there's actually been some very positive media coverage on that aspect and the way that the decision, has come to in a very fair manner. International standards being applied, and people basically saying, some media coverage saying, that these principles should now be applied in Cambodian courts. I think that's a very important part of the work we do, as Bill says. That we are here to build capacity in this country as well as trying these cases.
With that said, the trial chamber did not come out with a decision on whether or not the statute of limitations has run on crimes under the Cambodian Penal Code that existed at the time. How would that figure into case 2, and do you think that there's any symbolic importance to that in the sense that the defendant was charged and convicted of international crimes, but not of domestic crimes that existed at the time?
Ultimately, the national crimes, as you know, are subsumed under crimes against humanity, and in some cases under the Great Breach of the Geneva Conventions. For crimes against humanity, of course, you would have to prove murder and torture and these extra elements of widespread and systematic attack, which, as Andrew said, the court has found. The idea of subsuming national crimes or lesser crimes into greater crimes is a practice that's used in other international criminal courts, and it's a reasonable way to have a clear, simple judgment. The fact that they haven't made a decision on whether the national crimes would apply, or they postpone that, I think it's good for this court to be seen to be using as much of Cambodian law as they can. And so symbolically, it's nice to see the national crimes there, but it really is an issue of principle, whether or not you can retroactively extend the period of limitations for the prosecution of those crimes. And it's an open question, and I think it will probably be raised in case file 2. But I think ultimately it's not of a major impact certainly on case file 2.
And let's face it, the crimes of which he was convicted are much more serious than the national crimes. It's important that national law applies when we're talking about crimes against humanity and great breaches of the Geneva Conventions compared to domestic law, which in all countries basically falls under these very, very serious international crimes.
With that said, and the fact that the case 2 defendants are considered usually to have more responsibility than Joy, the fact that they are very old and they're not in great health, some commentators believe that they may not live till the end of their trial. Has the prosecution made any special arrangements to try to expedite the proceedings so that the Cambodians can see justice done for members of the Khmer Rouge leadership that really went up to the top?
We're moving as quickly as we can, but obviously the speed with which the trial begins, the end of the investigative process, the issuance of the closing order, it involves different organs of the court. We have to do our work, they have to do their work. Certainly, we are now in the last stages of our final submission, which we have a 45-day period from the day that the case file was actually transmitted back to us. We will file that document well within that period, in fact, way before the end of that period, with the hope that that will basically allow the Office of the Co-Investigating Judges to, as quickly as possible, issue the closing order. Then we have the issue of appeals, if there are any against the closing order, which is going to take several months. So, in a sense, we're working as quickly and efficiently as we can, but we are also subject to the rules of procedure and the way this court works. I think the trial, realistically, is going to begin in the first quarter of next year, and we will do everything we can to move the trial along as quickly as we can. And indeed, we've made various proposals to the Rules Committee of amending certain rules to actually speed up the process in court. We wait and see, obviously, at plenary whether those rules are adopted. So the prosecution's actually working very hard to ensure that the case gets on as fast as it can and it basically completes as quickly as it can do.
The only other thing I can add is that, justice is not just about an end result, it's really a process. And what the Cambodian population and many people around the world want to see the end to impunity and accountability for what has happened in the Khmer Rouge period. The fact that the process has started and it's operating in a standard that's akin to, similar to the international standards, I think is something to be borne in mind, that justice is happening by the very fact that this process is in place.
You mentioned earlier the other international tribunals, and you both have extensive experience with some of the international courts elsewhere around the world. What unique aspects are there in this tribunal, and how do they contribute to the broader fields of international criminal law and international justice?
I think one of the weaknesses of certainly the Yugoslav War Crimes Tribunal and indeed of the International Criminal Court is that neither court was actually based in the country or countries where crimes have taken place, although indeed there is provision within the Rome Statute to hold trials locally. That hasn't been done yet. And I think one of the enormous strengths of this institution is that the trials are actually taking place in the country where the crimes were committed. And secondly, that international staff are working alongside national staff. At the Yugoslav War Crimes Tribunal, it took nearly a decade to really gain the confidence of local prosecutors in the countries of the former Yugoslavia, in the actual process of dealing with these crimes locally. And if you recall, the War Crimes Chamber that was actually set up in Sarajevo to deal with crimes, the establishment of that court, and indeed the encouragement of local prosecutors to deal with crimes, took a long time. And I attended many meetings in Bosnia and Serbia where the local prosecution staff and judges were extremely critical of the Yugoslav War Crimes Tribunal. Here, I'm actually, Bill and I, we work alongside our national staff. We're working on this project together, and indeed, the Cambodian Judiciary and Prosecution Service and the defence lawyers working here are completely invested in the process now. They will get credit at the end of the day, when the court completes its work, and I think that's extremely important. I think it does obviously subject us perhaps to more media scrutiny and criticism than was suffered by the Yugoslav War Crimes Tribunal, but I think in the long term, the legacy of this court will be that much more powerful because it is a Cambodian court.
And there's definitely a recognition by the Cambodian judiciary, by NGOs, by lawyers that Cambodia is a country that lost every democratic principle 30 years ago. And they talk about year zero, that Cambodia had to be rebuilt and bring back those democratic principles and bring back those professionals, those judges, those lawyers that can start to protect the rights of Cambodians, which perhaps at the moment are less protected because of the weakness of the courts. And the Prime Minister and the International Prosecutor has said that the National Prosecutor said that this court will help build the rule of law in Cambodia. And I think it's really important to understand the connection between this court dealing with the past by bringing people to account and actually helping lay out a map for the future that provides more protections for the Cambodian people, that strengthens the court, makes Cambodia a stronger country, particularly in Asia, and becomes to be an example of how a country can build itself back up from one that's been completely destroyed 30 years ago. And it's that connection, I think, is very important. And by the ECC putting into practice international fair trial principles relating to the rights of the accused, the rights of the victims, the rights of civil parties, that can be passed on to the local courts. And hopefully it will provide a catalyst and a movement of discussion to create change in Cambodia, which many people that have been involved in it are looking for very fast.
Gentlemen, thank you very much for your valuable insight.
Thank you.